Former Social Development Minister Bathabile Dlamini's perjury trial has been rolled over. The matter will resume at the Johannesburg Magistrate's Court tomorrow morning. The former Social Development Minister is facing a perjury charge after allegedly lying under oath at the Concourt inquiry, looking at her role in the 2017 Sassa debacle. Newzroom Afrika's Mnisi is live for us there outside the Johannesburg Magistrate's Court. Linda, a very good morning to you. A lot of the focus over the past few days, 2 days to be specific, has been around the issue of witnesses. We heard today Magistrate Betty Khumalo expressing her confusion and dissatisfaction, saying that, telling the state that more could have been done to ensure that the witnesses are brought in.
Yeah, indeed, Paul. This case has had to be rolled over to tomorrow because the state failed once again to secure its witnesses. Yesterday, you'll remember, they asked for a postponement to consult with 2 of its witnesses. They indicated that they probably would be able to start with the case today. Now, today, arriving in court, indicating that after that consultation with their first witness, Zoda Mvulani, they determined that she was no longer a suitable witness, which left them with the last witness, Thokoza, saying that, in fact, that witness lives in 2 different provinces and they've had issues with getting a hold of that witness via cell phone. They've even sent the witness messages, but the witness is not responding to the messages. The magistrate saying that it feels that the state has not been doing enough to try and secure those witnesses. More could have been done. This matter has been set down for 3 days, and it seems every day, there are postponements. The state asking for a postponement to next year, but we also saw the defense opposing that particular application or request. We'll be speaking to the NPA's Pindi Mjonondwane right now, who'll give us a sense of where the state is. So, Pindi, thank you so much for your time. We heard the magistrate really saying that the state could have done much more to try and secure the witness. It seems to her that not much effort is being put in securing these witnesses. There are other cases that could have taken today's time, but we're still dealing with the same issues. I mean, could you say that you're not ready here?
Linda, we are ready. We have already submitted the bulk of the evidence that we have in the case. That evidence is before the court. However, as the NPA, we are not in control of what our witnesses then do after being informed that they are now witnesses of the state and have submitted their statements. We are not in control of that as the NPA. However, what we are in control of is making sure that we get them ready for court. And we believe as the NPA that we have done our utmost best to ensure that come this day, the witnesses are before court. Yesterday, as you have seen, the first witness that we are supposed to call was present. We just needed to consult with her to ensure that we were ready, and upon consultation with her, that's when we decided as the NPA that she is no longer a suitable witness. And we have also had challenges in reaching her over her cell phone, and that's the only communication tool that we were relying on as the NPA, because she already informed us that she was living between 2 provinces, between the Northwest and Limpopo province. So therefore it would have been fruitless for us to spend state resources to go to the Northwest when we could not get a confirmation that she's in the Northwest, and she has already indicated that she moves between the 2 provinces.
One of the concerns here is that this consultation could have happened before trial started. I mean, pre-trial. The state indicated that it was ready to start with the trial. The issues of consultation, what one might say, could have been dealt with before, and you would have determined that this first witness was not a suitable witness then. How did it get to this point that you're only doing your consultations now and you're unable to even secure witnesses? Are we seeing a Senegal or, Brendan Horner 2.0 here?
No, Linda. This is a totally different case. As I've already said, that the bulk of the evidence, which is the transcribed record of proceedings of the inquiry, that record is before court already. That is what mostly this case is based on. So our prima facie evidence has already been submitted in court. What we needed to do was to get witnesses to corroborate that bulk of the evidence that is already before court. Otherwise, we could have just submitted the record as the state and closed our case, because the bulk of the evidence that this case is reliant on is already before court. Coming to your question of the consultation, and we already mentioned in court that we had challenges to get hold of both witnesses. So one witness is in KZN and the other witness is the one that I said lives between the two provinces. So we have tried our utmost best as the NPA, but as I've said earlier on, that we are not in control of what witnesses then do after they have been informed that they are state witnesses and they have willingly submitted their statements to show that they are giving us cooperation to say we will be there to testify, this is my statement. But what then happens afterwards, unfortunately as the NPA, we are not in control of that. But what we are in control of is the type of evidence that we want to present in court, and that has already been done.
How does not having your witnesses here in court, or say for example they don't come at all, how would that impact on your case? Because it would be on prima facie evidence that there would be prospects of a successful prosecution here. So how would that impact on your case?
As I've said, that we had two options. We could have just submitted the record of proceedings, then close our case as the state. But we chose to have one or two witnesses that will come and corroborate that evidence that is already before court. So whether we have a witness or not, it doesn't really have an impact on the type of case that is before court, because the type of prima facie evidence that we are reliant on is already submitted in court. It's already with the court.
Do you think you'll be ready tomorrow?
Well, we cannot confirm that as the NPA, because we are reliant on other stakeholders to make those arrangements for us. They are not directly made by the NPA. We know that issues of witnesses are dealt with by the Department of Justice. The prosecutor currently went to meet with the court manager here to see if those arrangements can be done by today, so that we have the witness before court tomorrow.
John Ndwane there is the NPA spokesperson, telling us that in fact the state is ready, based of course on the prima facie evidence. They could even decide to close the case. So the matter then is rolled over to tomorrow. The magistrate indicating that they were, everybody indicated earlier in the case that they were ready to go on trial. There may have been other cases that may have, been allocated this time. So in the interest of justice then, she did not grant the postponement to next year, but instead rolled it over to tomorrow.
Very well, Linda, Mnisi, let's leave it there for now. I suppose we'll just have to wait and find out what then happens tomorrow at the Johannesburg Magistrate's Court.